Verdict. The formal decision rendered by the jury or by the judge in a bench trial, resolving the factual questions at the heart of the case and determining whether the defendant is guilty or not guilty in a criminal case, or whether the plaintiff or defendant prevails in a civil case. Acquittal. A verdict of not guilty in a criminal case, formally establishing that the prosecution failed to prove the defendant's guilt beyond a reasonable doubt and resulting in the defendant's immediate release from any criminal jeopardy for the charged offense. Conviction. A verdict of guilty in a criminal case establishing that the prosecution proved each element of the charged offense beyond a reasonable doubt, triggering the sentencing phase of the proceedings and all associated legal consequences. Not guilty. The formal verdict by which the jury declares that the prosecution has failed to meet its burden of proof, which does not mean the jury concluded the defendant is innocent, but only that guilt was not established to the required legal standard. Not guilty by reason of insanity. A special verdict available in criminal cases when the defendant successfully establishes an insanity defense, resulting in an acquittal of the criminal charge, but typically leading to civil commitment to a mental health facility rather than unconditional release. Guilty but mentally ill. A verdict available in some jurisdictions as an alternative to not guilty by reason of insanity, finding the defendant criminally responsible despite a mental illness and typically resulting in a standard sentence with a requirement that mental health treatment be provided during incarceration. General verdict. The most common form of verdict in which the jury announces only the ultimate conclusion, guilty or not guilty in criminal cases, or for the plaintiff or defendant in civil cases, without specifying how they resolved individual factual disputes. Special verdict. A verdict form requiring the jury to answer specific factual questions about the case rather than simply announcing a winner, after which the judge applies the law to those findings to determine the legal outcome. Partial verdict. A verdict in which the jury finds the defendant guilty on some charges but not guilty on others, or in a civil case resolves some claims in favor of one party and others in favor of the opposing party. Directed verdict. A verdict entered by the judge without jury deliberation when the evidence presented by one party is so legally insufficient that no reasonable jury could find in their favor, effectively ending the case before it reaches the jury. Polling the jury. The process of individually asking each juror after the verdict is announced whether the stated verdict is truly their own personal verdict, ensuring that the decision was reached voluntarily without coercion and reflects the genuine agreement of each juror. Reading the verdict. The formal courtroom proceeding in which the jury foreperson or the court clerk reads aloud the jury's decision in open court in the presence of the parties, their attorneys, and typically the public and press. Verdict form. The official written document provided to the jury that structures their deliberations by presenting the specific questions they must answer and the format in which they must record their findings and ultimate decision. Judgment. The court's formal official decision resolving the case, incorporating the verdict and any additional legal conclusions, and serving as the final authoritative statement of the parties' rights and obligations as determined by the court. Sentencing. The formal judicial proceeding following a criminal conviction in which the judge imposes the punishment to be served by the defendant, guided by statutory requirements, sentencing guidelines, and the specific circumstances of the offense and offender. Sentencing hearing. A court proceeding held after conviction in which the judge receives information from the prosecution, defense, victim, and probation department before determining the appropriate punishment to impose on the convicted defendant. Presentence Investigation Report, PSI. A comprehensive report prepared by a probation officer before sentencing, detailing the defendant's criminal history, personal background, employment, family circumstances, and the circumstances of the offense used by the judge to make an informed sentencing decision. Sentencing guidelines. A framework established by legislatures or sentencing commissions that provides judges with recommended ranges of punishment based on the severity of the offense and the defendant's criminal history, promoting consistency and reducing sentencing disparities. Mandatory minimum sentence. A legislatively prescribed minimum term of imprisonment that a judge must impose upon conviction for certain offenses regardless of mitigating circumstances, removing judicial discretion to impose a lesser sentence below the statutory floor. Maximum sentence. The longest term of imprisonment permitted by statute for a particular offense, establishing the ceiling beyond which a judge may not sentence, regardless of the severity of the conduct or the defendant's criminal history. Determinate sentence. A fixed prison term of a specific duration imposed by the judge that the defendant must serve in its entirety, minus any applicable good time credits, with a certain release date established at the time of sentencing. Indeterminate sentence. A sentence specifying a range of time, such as 5 to 10 years, rather than a fixed term, leaving the actual release date to be determined by a parole board based on the defendant's conduct and rehabilitation during incarceration. Concurrent sentences. Multiple sentences imposed for separate offenses that are served simultaneously rather than one after another, meaning the defendant's total time served equals only the longest of the individual sentences. Consecutive sentences. Multiple sentences imposed for separate offenses that must be served one after another rather than simultaneously, meaning the total time to be served equals the sum of all individual sentences, sometimes called stacked sentences. Enhanced sentence. A sentence that exceeds what would otherwise be the standard range due to aggravating factors such as the use of a weapon, prior criminal history, targeting a vulnerable victim, or the defendant's leadership role in a criminal enterprise. Aggravating factors. Circumstances surrounding the offense or the offender that justify imposing a more severe sentence than the standard range, such as the particular cruelty of the crime, the vulnerability of the victim, or the defendant's prior criminal record. Mitigating factors. Circumstances that justify imposing a less severe sentence than the standard range, such as the defendant's lack of prior criminal history, their role as a minor participant, evidence of rehabilitation, mental illness, or genuine remorse. Victim impact statement. A written or oral statement delivered at sentencing by the crime victim or their family members describing the physical, emotional, psychological, and financial harm they suffered as a result of the defendant's offense. Character letters. Written statements submitted to the court at sentencing by people who know the defendant, family members, employers, community members, attesting to positive qualities, contributions, and the defendant's potential for rehabilitation. Allocution. The defendant's formal opportunity to speak directly to the judge at sentencing before punishment is imposed, allowing them to express remorse, explain their circumstances, or make a personal plea for leniency. Sentence imposed. The judge's formal oral pronouncement of the punishment to be served, stated in open court in the defendant's presence, and subsequently entered into the official record as part of the judgment of conviction. Incarceration. The sentence of confinement in a jail or prison facility as punishment for a criminal conviction, ranging from brief terms in a local county jail for misdemeanors to lengthy terms in state or federal prison for felonies. Imprisonment. Confinement in a state or federal correctional facility serving a sentence of more than 1 year, typically reserved for felony convictions and involving housing in an institution separate from local jails used for misdemeanants and pretrial detainees. Jail. A local correctional facility operated by a county or municipality used to house defendants awaiting trial and individuals serving short sentences, typically for misdemeanor convictions of 1 year or less. Prison. A state or federal correctional institution housing individuals serving sentences exceeding 1 year for felony convictions, offering various security levels from minimum to maximum security, depending on the nature of the offense and the perceived risk posed by the inmate. Suspended sentence. A sentence that is imposed by the judge but not immediately carried out, allowing the defendant to remain in the community under specified conditions, typically probation, with the understanding that the sentence will be activated if they violate those conditions. Probation. A sentence allowing a convicted defendant to remain in the community rather than serve time in prison, subject to court-imposed conditions such as regular check-ins with a probation officer, drug testing, community service, and restrictions on travel or association. Supervised probation. The most common form of probation, requiring the defendant to report regularly to an assigned probation officer who monitors compliance with all conditions of the sentence and reports violations to the court. Unsupervised probation. A less intensive form of probation in which the defendant is subject to conditions but is not required to report regularly to a probation officer, typically reserved for low-risk offenders convicted of minor offenses. Conditions of probation. The specific requirements imposed by the court as part of a probation sentence, which may include maintaining employment, abstaining from alcohol or drugs, submitting to random testing, completing counseling, performing community service, and staying away from certain people or places. Probation violation. A finding that a defendant has failed to comply with one or more conditions of their probation, which may result in a revocation hearing and imposition of the original suspended sentence or other modified punishment. Revocation hearing. A court proceeding in which the judge determines whether a defendant has violated the terms of their probation or parole, and if so, what consequences should follow, up to and including incarceration for the remainder of the original sentence. House arrest. A sentencing alternative in which the defendant is confined to their home rather than a correctional facility, typically enforced through electronic monitoring with an ankle bracelet that tracks their location and reports any violations. Electronic monitoring. The use of technology, most commonly an ankle bracelet transmitting GPS data, to track a defendant's location and ensure compliance with the geographic restrictions of house arrest, curfew, or other location-based conditions of release or supervision. Community service. A sentencing condition or alternative requiring the defendant to perform a specified number of hours of unpaid work for a nonprofit organization or government agency, serving both as punishment and as a way to contribute positively to the community. Fines. Monetary penalties imposed as part of a criminal sentence, either as the sole punishment or in addition to incarceration or probation, representing the court's financial sanction for the offense committed. Restitution. A financial obligation imposed as part of a criminal sentence requiring the defendant to compensate victims for the actual economic losses they suffered as a direct result of the crime, including medical expenses, lost wages, and property damage. Forfeiture. The court-ordered surrender of assets, money, property, or other items connected to criminal activity, either as part of the sentence or as a separate civil proceeding designed to deprive offenders of the proceeds and instrumentalities of crime. Diversion. A pre-conviction alternative to traditional prosecution in which a defendant agrees to complete certain conditions, such as treatment, education, or community service, in exchange for having charges reduced or dismissed without a formal conviction. Deferred adjudication. A form of diversion in which the court accepts a guilty plea but defers entering a formal conviction, allowing the defendant to complete a period of supervision or other conditions after which the charges may be dismissed if they comply. Split sentence. A sentence combining a period of incarceration with a subsequent period of probation, requiring the defendant to serve time in custody first before transitioning to supervised release in the community. Boot camp. An alternative sentencing option, also called shock incarceration, modeled on military training, involving a short but intensive period of strict discipline, physical conditioning, and structured programming as an alternative to a longer standard prison term. Work release. A program allowing incarcerated individuals to leave the correctional facility during the day to maintain employment and return at night, designed to facilitate the transition back to the community while still serving a sentence. Weekend sentence. A sentencing arrangement allowing a defendant to serve their jail time on weekends rather than continuously, permitting them to maintain employment and family obligations during the week while still fulfilling the incarceration component of their sentence. Capital punishment. The sentence of death imposed by the state for the most serious criminal offenses, typically first-degree murder with special circumstances, subject to extensive constitutional requirements and appellate review before it may be carried out. Capital case. A criminal prosecution in which the prosecution is seeking the death penalty, subject to special procedural protections, including a bifurcated trial with separate guilt and penalty phases and heightened appellate review. Penalty phase. The separate proceeding conducted after a guilty verdict in a capital case in which the jury hears additional evidence about aggravating and mitigating factors before deciding whether to recommend the death penalty or a lesser sentence. Death row. The section of a prison facility housing inmates who have been sentenced to death and are awaiting execution, often for years or decades, while their cases proceed through the appellate and post-conviction review process. Lethal injection. The most commonly used method of execution in the United States, involving the intravenous administration of a combination of drugs designed to render the condemned person unconscious and then stop their heart. Clemency. The power of a governor or the president to reduce, modify, or eliminate a criminal sentence, including the power to grant a pardon, commutation, or reprieve, typically exercised in capital cases as a final check before execution. Appeal. A formal request to a higher court to review the trial court's decisions, verdict, or sentence for legal error, argued on the basis of the trial record without presenting new evidence, and resulting in the appellate court affirming, reversing, or remanding the case. Post-conviction relief. Any of several legal mechanisms available to convicted defendants after their direct appeal is exhausted, including habeas corpus petitions, motions based on newly discovered evidence, and claims of ineffective assistance of counsel. Habeas corpus. Latin for you shall have the body, a writ requiring that a person held in custody be brought before a court to determine whether their detention is lawful, serving as a fundamental safeguard against unlawful imprisonment available even after all direct appeals have been exhausted. Ineffective assistance of counsel. A constitutional claim asserting that the defendant's trial attorney's performance was so deficient, and the deficiency so prejudicial to the outcome, that the defendant was effectively denied their Sixth Amendment right to counsel. Brady violation. A constitutional violation occurring when the prosecution fails to disclose material evidence favorable to the defendant, including exculpatory evidence or information that could be used to impeach prosecution witnesses, in violation of the rule established in Brady v. Maryland. Newly discovered evidence. Evidence that was not available at the time of trial despite the exercise of due diligence, which if presented to the jury might have produced a different verdict, potentially forming the basis for a new trial or post-conviction relief. Exculpatory evidence. Evidence tending to show that the defendant did not commit the charged offense or that reduces their culpability, which the prosecution is constitutionally required to disclose to the defense, regardless of whether it was specifically requested. DNA exoneration. The use of DNA testing to definitively establish that a convicted person did not commit the crime for which they were imprisoned, leading to their release and the vacating of their conviction. A growing phenomenon that has revealed flaws in the justice system. Innocence Project. A nonprofit legal organization dedicated to exonerating wrongfully convicted individuals through DNA testing and other evidence, and to reforming the criminal justice system to prevent future wrongful convictions. Wrongful conviction. The conviction of a person who did not commit the crime for which they were found guilty, resulting from factors such as false confessions, mistaken eyewitness identification, inadequate defense counsel, prosecutorial misconduct, or flawed forensic evidence. Parole, the supervised early release of a prisoner before the completion of their full sentence, granted by a parole board upon a finding that the prisoner has been rehabilitated and no longer poses a danger to the community, subject to conditions similar to probation. Parole board, the administrative body, typically composed of appointed officials, that has the authority to grant, deny, or revoke parole for eligible prisoners, making discretionary decisions based on the nature of the offense, institutional behavior, and rehabilitation progress. Parole hearing, the formal proceeding before the parole board in which a prisoner presents evidence of rehabilitation and readiness for release, typically with input from the prosecutor, victims, and correctional staff before the board renders its decision. Conditions of parole, the requirements imposed on a parolee as a condition of their early release, similar to probation conditions and typically including regular reporting to a parole officer, restrictions on travel, prohibitions on drug and alcohol use, and requirements to maintain employment. Parole officer, the government official responsible for supervising parolees in the community, monitoring compliance with conditions of release, providing support services, and reporting violations to the parole board or court. Parole revocation, the process of returning a parolee to prison for violating the conditions of their release, initiated by the parole officer and resulting in a hearing before the parole board or a court to determine whether revocation is warranted. Good time credit, a reduction in the time a prisoner must serve in custody, earned through good behavior and compliance with institutional rules, designed to incentivize positive conduct and facilitate an earlier release date. Earned time, sentence reduction credits earned through participation in educational programs, vocational training, or rehabilitative programming, distinct from good time credits for mere compliance with rules. Mandatory release, the automatic release of a prisoner upon reaching a specified date determined by their sentence minus applicable good time credits, not subject to the discretionary decision of a parole board. Supervised release, a form of post-incarceration supervision in the federal system imposed by the sentencing judge as part of the original sentence rather than granted by a parole board, requiring the released individual to comply with conditions monitored by a probation officer. Halfway house, a transitional residential facility housing individuals recently released from prison or nearing the end of their sentence, providing a structured environment with supervision, programming, and support services to facilitate reintegration into the community. Re-entry, the process by which formerly incarcerated individuals transition back into the community after release, encompassing practical challenges such as finding housing, securing employment, rebuilding relationships, and complying with ongoing supervision requirements. Expungement, a legal process by which a criminal arrest or conviction record is sealed or destroyed, effectively treating the offense as if it never occurred and allowing the individual to legally deny the existence of the record in most circumstances. Sealing of records, a court order restricting public access to criminal records without destroying them, making them invisible to most background checks while preserving them for law enforcement and certain official purposes. Set aside, a court order vacating a criminal conviction after the defendant has successfully completed their sentence, available in some jurisdictions as an alternative to expungement, though the conviction may still be disclosed in certain circumstances. Certificate of Rehabilitation, a court-issued document available in some jurisdictions to individuals who have demonstrated sustained rehabilitation after completing their sentence, serving as evidence of good character and potentially supporting the restoration of certain civil rights. Pardon, an executive act of clemency by a governor or the president that forgives a criminal offense and restores the individual's civil rights, either conditional upon certain requirements or unconditional, but typically not erasing the underlying conviction from the record. Commutation, the reduction of a criminal sentence to a lesser punishment, such as reducing a death sentence to life imprisonment or shortening a prison term, by executive action without affecting the underlying conviction itself. Reprieve. A temporary postponement of the execution of a sentence, most commonly a death sentence, providing additional time for legal review or the consideration of clemency without permanently altering the ultimate punishment. Restoration of civil rights. The process of returning rights lost upon felony conviction, including the right to vote, serve on a jury, hold public office, and in some jurisdictions possess firearms, either automatically upon completion of sentence or through a separate legal proceeding. Collateral consequences. The civil penalties and disabilities that attach to a criminal conviction beyond the direct sentence imposed by the court, including loss of voting rights, ineligibility for public benefits, deportation for non-citizens, restrictions on housing and employment, and professional license revocation. Felon disenfranchisement. The loss of the right to vote resulting from a felony conviction, the scope of which varies dramatically by jurisdiction. From permanent lifetime disenfranchisement in some states to automatic restoration upon release from incarceration in others. Sex offender registration. A post-conviction requirement imposing ongoing obligations on individuals convicted of qualifying sexual offenses to register their current address, workplace, and other information with law enforcement, typically maintained on publicly accessible databases. Deportation. The removal of a non-citizen from the United States following a criminal conviction that renders them deportable under immigration law, one of the most severe collateral consequences of a criminal conviction for non-citizen defendants. Civil judgment. The court's formal determination in a civil case of the party's legal rights and obligations, specifying whether the defendant is liable, and if so, the remedy to which the plaintiff is entitled. Judgment for plaintiff. A civil judgment finding in favor of the person who filed the lawsuit, establishing that the defendant is liable and ordering them to provide the remedy sought, whether monetary damages or other relief. Judgment for defendant. A civil judgment finding in favor of the person who was sued, establishing that the plaintiff failed to prove their case and that the defendant has no liability, entitling the defendant to walk away without paying any damages. Default judgment. A judgment entered against a party who failed to appear, respond to the complaint, or otherwise participate in the litigation, effectively allowing the opposing party to win without a contested trial. Judgment creditor. The party who has won a civil judgment entitling them to receive money or other relief from the opposing party, giving them the legal right to pursue collection if the opposing party fails to pay voluntarily. Judgment debtor. The party against whom a civil judgment has been entered, who is legally obligated to pay the awarded damages or comply with any other court-ordered relief. Satisfaction of judgment. A formal acknowledgment filed with the court confirming that the judgment debtor has fully paid the amount owed, officially closing the judgment and releasing the debtor from further collection efforts. Enforcement of judgment. The legal process by which a judgment creditor compels payment from a judgment debtor who has not voluntarily complied, including mechanisms such as wage garnishment, bank levies, and liens on real property. Garnishment. A legal procedure allowing a judgment creditor to collect money owed under a judgment by ordering a third party, typically the debtor's employer or bank, to withhold and remit funds directly to the creditor. Lien. A legal claim placed on a debtor's property, such as real estate or a vehicle, as security for a debt or judgment, preventing the property from being sold or transferred without first satisfying the outstanding obligation. Levy. The legal seizure of a judgment debtor's property by a court officer to satisfy an unpaid judgment, typically involving the taking and sale of personal property or the freezing of bank accounts. Writ of execution. A court order directing a law enforcement officer to take action to enforce a civil judgment, such as seizing and selling the debtor's property, garnishing wages, or otherwise compelling payment. Attachment. The legal seizure of a defendant's property at the beginning of a lawsuit, before judgment, to prevent them from dissipating assets that might be needed to satisfy a future judgment, typically requiring a court order and a showing of likely success on the merits. Judgment line. An automatic lien that attaches to a judgment debtor's real property in the county where the judgment is recorded, preventing transfer of the property without satisfying the judgment and serving as security for the debt. Post-judgment interest.
Interest that accrues on an unpaid civil judgment from the date it is entered until it is fully satisfied, calculated at a rate established by statute, and designed to compensate the judgment creditor for the time value of money during the collection period.